Good evening, friends. In the last video, I told you about the negligence of the doctors, and we discussed that the hospitals which give free service to certain people and collect heavy amount from other patients, they also come under the purview of the Consumer Protection Act. That means anybody can file cases against them. Now, today we are discussing an instance where the Supreme Court held that the doctors should not be unnecessarily dragged into the criminal courts just like the ordinary criminals. This is what the crux of the judgment says. So, the Supreme Court, while delivering a judgment in criminal appeal number 770 by 2009, and you can refer the case as Anjana Agnihotri and another versus State of Haryana and another 2009. And in this case, the Supreme Court held that the doctors or the medical professionals, they may have to take decisions in a quick manner and at the end of the life of the patients, and they may not be proved to be successful at some times, but for that reason the doctor should not be held accountable or responsible unless there is a grave negligence, and the negligence is such an extent that the doctor has exhibited, then only they should be taken to task. Right. Now let's know what happened. This incident took place on 15/11/1998. So on 15/11/1998 around 5 a.m., that is in the early hours, so one woman, a pregnant woman by name Santosh Rani, she was admitted in this hospital at about 5 a.m. Right. So the doctor Agni, she is Anjana Agnihotri, she conducted cesarean operation, and the woman delivered a baby boy, and this woman operation was conducted at about 8 a.m. Fine, the boy was delivered, but the condition, there was much less blood in the body of the so-called Santosh Rani. Therefore, the doctor felt that blood transfusion is immediate and necessary. So normally they have contacted the husband, others, and luckily the husband, their relatives, close relatives, Nandalal and his brother Bhajanlal, they have offered to donate the blood, and immediately the blood was taken and also the transfusion took place. But incidentally, at about 2 a.m. on the next morning, that is on 16/11/98, at about 2 a.m. she died. Right? Then her brother, that Nandalal, he has filed an FIR alleging gross negligence on Dr. Anjana Agnihotri, stating that she did not attend the patient right from 2 p.m. of 15/11/98 to 2 a.m. of 16/11/98, due to which the woman died. Therefore, she has exhibited criminal negligence, not medical negligence, criminal negligence. Yes, the police registered a case and they filed the charge sheet against her. And as far as investigation is concerned, incidentally, the post-mortem certificate, it revealed that the transfusion of blood is not the cause for her death. Right? Therefore, now the matter has come to the Supreme Court. In this case, the Supreme Court relied on the famous case, the celebrated case of Jacob Matthew versus State of Punjab, 2005, and therefore decided that the medical officers who have to take decisions, definitely they cannot be dragged to the court unnecessarily, because at that particular point of time they have to decide. They have to decide as to which operation they have to do. They have to decide as to which medication they have to give. And simply because it failed, we can't hold the doctors accountable. So for this, there is a test called as Bolam test. The Bolam test should be done. Anyway, in this case, the Supreme Court held that don't arrest the accused in a routine way. Just like our 304 road accident victims, the doctor should not be arrested and they should be given, they should be treated separately. And here, the investigation, the SC also, Supreme Court provided certain guidelines. So for that, the guidelines are: number one, the investigating officer should, before proceeding against the doctor, take an independent and competent medical opinion. Independent and competent medical opinion, preferably from a doctor in government service, please remember, and qualified in the branch of the particular medical practice, and who can normally be expected to give an impartial and unbiased opinion applying the Bolam test. So let us know what is the Bolam test. Bolam test means is a very famous case. It is also Bolam versus Frayan Management Hospital 1957 case. In this case, at the time, the during England court, it held that only 2 points. So whenever a charge is made, the plaintiff has to prove the facts. Number 1, there was a duty of care between the doctor or nurse and the patient. Duty of care. So you may be knowing what is a tort or what is a medical negligence. Negligence is the failure of or breach of duty of care. So the first point is that there should be a relation, duty of care between the doctor and the patient. And the second point is the act of the doctor, the act of the nurse or the act of omission is breached, it has caused a breach to the rule of the so-called caution or duty of care. So this is what is called Bolam test. If this condition, actually this is a case of Bolam versus Frayan, F-R-I-E-M, Frayan Hospital Management Committee 1957, right? So basing on this and the guidelines, actually they were given in Bolam test only. What is that? That an independent opinion, an opinion from independent doctor, particularly from the doctor in government service, it has to be taken. But friends, you may be knowing there is a criticism also, because Bolam test says, once again, take opinion from another doctor, from another independent doctor, from another impartial doctor. Will it be done? Is it possible? So normally the doctors category, they may try to defend another doctor. It may not be possible. Therefore, this type of criticism is also there. But anyway, so the medical profession. So normally we give respect to the doctors. Normally we treat them as demigods or semi-gods. Whenever you are not feeling well, you will go to the doctor with the great hope that he will treat him and relieve you of the pain. Is it not? So certain that much of importance or sanctity we give to the doctors. Of course, doctors also normally 90% of them, they have to take decision. That's why section 87 and 88 with the Indian Penal Code give a provision of exception to them. Normally, whenever you go to the hospital and if the condition is serious, they take the signature, either yours or the patient's, somebody's signature, taking that if anything happens, they will not be held responsible. They will do their duty, they will conduct the operation. Now in this particular case, the failure on the part of the doctors is that they have not followed the procedure while transfusion of blood according to the ICMR guidelines. That's only. But the PM report stated that she did not die of the failure of the transfusion of blood, but because of some other complications, for which we cannot attribute the so-called highest negligence on the part of the medical officers. So friends, this is a good case where you can defend the doctors, stating that doctors cannot be held just like ordinary people, just like this case actually was registered under section 304A IPC and also 3, 7 and 8 of Drugs and Magic Remedies Act. Of course, that is not important. 304A normally it will be registered or the cases will be booked on the fellows who drive the vehicles in a rash or negligent manner or caused the death of persons. So such an important section should not be misused or very casually should not be applied on the doctor of medical officers. And therefore, please remember, Anjana Agnihotri case comes to the defense, comes to the rescue of the medical officers under the Consumer Protection Act. Normally here they also do some service. The service is definitely, so if there is any deficiency service under section 210 of the Consumer Protection Act, definitely you can file a case. But before filing the case or before taking the case on file or the magistrate before the private case on file, they have to see whether there is attributable criminal negligence on the part of the doctor or not. If it is a simple negligence, so normally you can get compensation, but not a criminal trial. Friends, this is the crux of the case. So please refer to, we have discussed 3 cases now. Number 1 is Anjana Agrawatri versus State of Haryana, Nandar 2009. Second case is Jacob Matthew versus State of Punjab. Of course, in that case also, please remember, same case. Actually, he was a retired officer, Ashok Sharma, brought his father and got him admitted in the CMC hospital in Ludhiana. So here what happened is, on the particular day, I will tell you the date also, maybe on Ashok Kumar, maybe 15 to 1995. On 15 to 1995, he was admitted, but after a week, so actually after a week, that is 22 to 95, the father, he got a breathlessness. Immediately, they asked, he has Ashok, Vinod Lal actually, Vinod Sharma, who was present with the father, he elected the nurse, who in turn called the doctor, but the doctor did not turn up till 20-25 minutes. At that time, Jacob Matthew has come, and immediately they tried to give oxygen to that old man. Immediately, the oxygen from the neighboring room was bought and it was put in the mouth of the old man, but he still was feeling restless. He was trying to get up, and the hospital staff, the nurses, others, they wanted to remain in bed. Ultimately, after 2 minutes, it's learned that the oxygen cylinder was empty. How horrible it is. Next, immediately, Vinod Sharma, he has gone to some other room and brought another cylinder, but by the time his father died, and they have filed a case of negligence there also, the Jacob Matthew cannot be held responsible because he came after 25 minutes because he was busy with attending on the other patient. And since the oxygen is not available, since the management has to be held liable, not the doctor. So it was that case. So we discussed the Jacob Matthew versus State of Punjab case 2005, and the most important, that is Bolam test. So Bolam versus Paraya management 1957 case, and of course there was some criticism on Bolam test, and later it was advanced Bolito test. Bolito test also come into this. Of course, if I continue telling like this, so many tests are there. Let us stop here. So this is a good case where the doctors cannot be held negligible for each and everything. Right? Thank you very much.